Hello, and welcome to the first in a series of discussions about the issues affecting global firms, particularly with UK and US operations, and some of the common issues that come up in practice. I'm here with my excellent partner, Nick Leale, who is a leading regulatory specialist. And Nick, you have particular experience, sort of frontline experience in both advising and handling these kind of cross-border issues, particularly in a regulatory context.
Yes, and of course the two systems are very different. The UK system is, of course, a bigger picture approach with the reputation of solicitors in mind, and of course in the US it's the clients that are the primary concern, and the rules are driven there by loyalty to the clients.
So just talk us through a typical situation that you would see in a US UK firm being held
Well,
out as all one firm
yeah,
around conflicts. Kind of what would that look like from the say the US partner perspective and the UK receiving partner perspective?
yeah. Well, often the US is where the conflict checks will actually take place, and often hits will come up because, of course, in the US system, it's about a whether there is a current or indeed former client that has some impact on the issue that's being inquired of by the UK partner,
Mhm.
and that will immediately often lead to the US partner seeking a waiver from the UK partner in order for the matter to proceed.
And from the UK partner's perspective, receiving that request, what does that look like in practice, and how do they typically respond? And I guess their clients respond as well.
In those situations, usually the UK partner will be provided with a template waiver document to put to their client, and that's often sometimes where the issues can begin, because that's something which UK clients, of course, will be very unfamiliar with, and won't have seen a document that's often of some length before.
And what's the typical response that you would get from a UK partner to that sort of request?
Well, often they'll be slightly concerned about it because it's not something. It's likely that their client won't have seen something before like it, and also may query why it is that it's being suggested that they need to sign such a document when the likelihood is that the UK partner has formed the view that on the UK rules there isn't actually a conflict in the interests of that client and the client for whom there has been the hit on the US system.
Okay, so we've got two different systems which actually take quite a different approach to conflicts and conflict management. Can you give us kind of a thumbnail
Yes.
sketch of your experience of the US system and your knowledge of the UK system?
Well, in the UK, obviously, the requirement is that if there is any significant risk of a conflict between the interests of two particular clients, then that is a conflict, and it's a matter of judgment, and it depends on the circumstances of the matter.
Mhm.
Sometimes the US rules are considered quite similar, but actually they're very, very different, because in the US you cannot act for a current client if the representation of that client is directly adverse to another current client, unless there is a waiver in place. That is very different. And of course, the client still needs to be, the firm still needs to be able to provide competent and diligent representation, but they can act if there is a waiver in place, despite the fact that there may be on the UK rules a conflict of interest. Those systems are very different.
And so in the UK, we don't have this option of being able to go and get a waiver.
That's correct. And indeed, in the US, it also applies where there is a hit in relation to a former client. In the UK, of course, there may be an issue relating to an information conflict, but generally speaking, once a client is a former client, there is far less likely to be any kind of conflict issue arising. Whereas in the US, that is a situation where a waiver is required if the issue is the same, or there is some sort of connection between the matter and the previous matter for whom the firm acted for the former client.
So if you're sitting there as the GC or the head of risk, how do you sort of advise this US and UK partner who are trying to get to the same kind of goal. They both want the success of the firm. They both want to look after the clients. How do you advise them to and help them navigate these two different jurisdictional rules?
Well, the first thing to do is ensure that the local rules are considered first. But when they have been, the more stringent conflict rules are then applied to the situation as well. I think it's most important that everybody within the business understands the two schemes, obviously, and understands why the waivers are required, and are able to give a proper and detailed explanation to the client when they send that waiver to them as to why they're being asked to sign it. And that requires, of course, very clear conflict policies in order to ensure consistency of approach across the two offices to resolve the conflicts that are issue, and also to manage expectations across the two offices.
And just tell me a little bit about, these waiver documents. What do they? I know we've talked previously about them being potentially like 10-page agreements, which if you're on the receiving end of that as a partner and being asked to go to your client, or where there might be an issue, I mean, what do they actually look like?
They're very lengthy. They're very lengthy documents that look like they're covering a whole myriad of issues, because that's how this issue is approached by US firms. And it's asking the firm, in effect, to accept that there may be issues relating to conflict present in relation to the relationship, but that they're still content for matters to proceed. Any proper consideration of those documents is probably going to set alarm bells ringing for the UK client, which is why it's all the more important that the UK partner understands what's behind the requirement and the content of the document, so that they can explain it properly to the client when the issue arises.
And then in terms of the policy that the firm itself has, sort of conflicts management policy, what will that typically look like from your experience?
Well, first of all, it needs to explain the differences between the two schemes, and how the firm's client onboarding teams will actually approach the issue, and a clear line of a clear clarity, I think, as to how partners across the two offices communicate in relation to the issues as they arise, and the circumstances in which they then take matters forward.
And what about training? I mean, how much training goes into sort of educating partners and, kind of risk teams around management of conflict issues, especially in what are often very short timescales, right? Everybody's keen to get the client and the deal onboarded.
And that is often one of the issues. It's the timescales in which these things have to progress, and all the more reason, therefore, why the partners have to understand the two schemes and be very clear that they will communicate with the partner in the other office in relation to the issue quickly when it does arise, so that the matter can be resolved as quickly as possible. But the training's crucial, because without it, there isn't an understanding of the rationale behind the document that sometimes has to be put in front of the UK client in relation to a conflict scheme, which is completely different to that which the UK client might be used to.
Yeah. So actually that front loading of policy and of training and building that sort of rapport and understanding between the partners who are going to need to collaborate very closely and quickly is really important, because otherwise actually you could really undermine a whole relationship and all the work that's been done in investing in an overseas jurisdiction like the UK. Maybe merging with a firm or building out a team, if they just don't understand systems and how they do and don't work together.
And I think sometimes there's perhaps is not an understanding in the US group of partners for whom this is gaining waivers in conflict situations is second nature. That it's something that arises less frequently for UK partners, and it is a scheme that is alien to them until they're used to it, because it is so focused on the client rather than the issue of whether there's actual conflict in the matter itself, as opposed between the two clients, one of whom may be a former client in the US.
So obviously we've focused on conflicts of interest, but what if you're in a situation where there's an information conflict? How is that addressed? Because that seems to me a potentially trickier dimension to this situation.
Yes, and it's an issue that you would hope that the UK lawyers will always have in mind, because it's that, and of course own interest conflicts as well, are the sort of issues that they have to consider separately, aside from any kind of waiver requirements. And indeed, information conflicts are still going to arise for the US, irrespective of whether a client is prepared and willing to sign a waiver document, because they can only sign those documents if they are content that there's no risk to them in relation to any kind of information that may have to be exchanged as a result of it.
So, Nick, thanks so much. It's so interesting and it's so relevant, because clearly there are more and more transatlantic mergers taking place. So this is going to be an even more active issue for partners and advisors on the front line to think about. Do you have any sort of final words of wisdom on this?
Well, no, only to agree with that. The fact is that the two conflict systems in the UK and the US are founded on two very different approaches, and they're not going to be reconciled anytime soon. And as a result, firms both sides of the Atlantic are going to have to be very, very aware of how they execute these issues when they arise.
Thank you for watching. I hope you've enjoyed it. If you have any questions, please do feel free to reach out to Nick, and I'd be very pleased to hear from you. And as I say, we have other follow-up episodes in this series, so please do look out for them, and hope to hear from you soon. Thanks so much. Bye. And thank you, Nick. That was brilliant. Thank you.
Thank you, Claire.